Well, this is a question which has been asked by lay people ever since the time of Shakespeare. People don't understand the reason why the lawyer is under a professional obligation, which is the highest professional obligation of a lawyer, to defend a person who is either unpopular or whom everybody believes to be guilty or whom he himself believes to be guilty. You see, we have inherited our professional traditions from the English bar and English judges. England produced one of their best lawyers in history. His name was Erskine, Lord Erskine. He ultimately became the Lord Chancellor of England. He was the Attorney General of England. But when he was a practitioner at the bar, he was called upon to defend Thomas Paine, the famous writer of the book on the rights of man. He was a libertarian. He was prosecuted in England on a charge of seditious libel. The King of England himself was the person who wanted this man to be jailed. Erskine was approached to appear for him. Many friends advised Erskine that please don't take up this case. He not only took up the case against all advice, but he delivered one of the best speeches in legal literature. And for the benefit of those who are attacking me, I will tell you what Erskine said to those who were attacking him. He said, "My name and character have been the topic of injurious reflection. And for what? Only for not having shrunk from the discharge of a duty which no personal advantage recommended and which 1,000 difficulties repelled. But, gentlemen, I have no complaint to make either against the printers of these libels, nor even against their authors. The greater part of them, hurried percept away by honest prejudices, may have believed they were serving their country by rendering me the object of its suspicion and contempt, and if there have been amongst them others who have mixed in it from personal malice and unkindness, I thank God I can forgive them also. Little indeed did they know me, who thought that such calumnies would influence my conduct. I will forever at all hazards," and this is that famous paragraph in English literature today, "I will forever at all hazards assert the dignity, independence and integrity of the English bar, without which impartial justice, the most valuable part of the English constitution, can have no existence. From the moment that any advocate can be permitted to say that he will or will not stand between the crown and the subject arraigned in the court where he daily sits to practice, from that moment the liberties of England are at an end. If the advocate refuses to defend, from what he may think of the charge or the defense, he assumes the character of the judge, nay, he assumes it before the hour of judgment, and in proportion to the rank and reputation, puts the heavy influence of perhaps a mistaken opinion into the scale against the accused, in whose favor the benevolent principle of English law makes all presumptions and which commands the very judge to be his counsel. He says, what is this nonsense? Am I not causing prejudice to a possibly innocent man if they say that a man like Erskine refused to take his case? That itself will be his condemnation. I said, I am not prepared to do it. And he explains that it is society which through the legislature has made a law that no one shall be convicted unless there is credible evidence to sustain the charge. And he says, the client who comes to me may say that you may have 10 witnesses against me, but all 10 are my enemies. You cross-examine them, find out, leave me to my luck, but you do your duty. And he says, it has happened that a case which has appeared to be dark on cross-examination and defense evidence, it has turned out to be a total farce and a total falsehood. Now, coming nearer home, my own experience. One of the cases in which I appeared for Professor Gilani, who was supposed to have been sentenced to death for the Parliament attack case. The same kind of propaganda went on against me, which you now are telling me exists on your television channels and the internet. I took up that case, and the High Court reversed the conviction and said that this is a case of no evidence. They appealed to the Supreme Court of India. The Supreme Court affirmed the verdict that this is a case totally devoid of evidence, except that there is some prejudice against the man. I saved an innocent life from the gallows. And today there are Muslim liberals who think that I am a pro-minority man. And I have at least won the affection and respect of so many people in this country by defending Professor Gilani. Take another case. I appeared for Balbir Singh, who had been sentenced to death for having murdered Indira Gandhi. I was not there in the trial court. He was sentenced to death. I appeared for him in the High Court and the Supreme Court. His conviction was set aside by the Supreme Court. They not only, this is not a case in which they gave him benefit of doubt. They recorded a finding that the case is false. And I saved an innocent man, and the whole Sikh community today is grateful to me that I saved the life of a single Sikh. My own experience and practice are founded on what Erskine said long ago, nearly 2 centuries ago in England. And in India, the matter is now a matter of law. The Bar Council of India has framed rules of professional conduct and etiquette. They are framed under the provisions of the Advocates Act. Any advocate who commits a breach of that rule is liable to be dealt with for professional misconduct and removed from the role of lawyers. Now, for the benefit of those who find fault with me, I am reading to you Rule 15, the duty which an advocate owes to the client. It shall be the duty of an advocate fearlessly to uphold the interests of his client by all fair and honorable means, without regard to any unpleasant consequences to himself or to any other. He shall defend a person accused of a crime, regardless of his personal opinion as to the guilt of the accused, bearing in mind that his loyalty is to the law, which requires that no man should be convicted without adequate evidence. If I don't follow this rule, I'll be held guilty of professional misconduct and thrown out of the bar. And some good people will then regret that they lost a good lawyer.
So my next question is...
I will tell you another. A young man in Pune was accused of having poisoned his wife and killed her, because they said that he had another affair with another woman and so on. He was also sentenced to death by the Sessions Court of Pune. I was engaged to appear for him in the High Court of Bombay. When people came to know that I was doing the case of this man, women's delegations came to me, preventing me from taking up the case. Some said dharna in my house. I said, ladies, no, I will take up the case. I said, I am sorry to disappoint you, but I want each one of you ladies to answer one question. If your son had been sentenced to death, would you seek a lawyer or would you not seek a lawyer? If you think you would seek a lawyer, what would you think of a lawyer who carelessly tells you that I don't take up the case of this rascal son of yours? Please leave me alone. They did leave me alone. The High Court did not agree with me.
Okay.
They confirmed the sentence of death. I took the case free to the Supreme Court of India. It's a reported judgment of 1984. It's one of the leading cases in criminal law, where the High Court, the Supreme Court, acquitted the man, and they said that this boy is innocent. And he was acquitted.